right, good evening, everybody. I would like to call to order the Village of Waterford's Board special meeting on April 6th, 2026 at exactly 6 p.m. If we could all rise and pledge the flag, please.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Rachel, do you have a roll call?
Yes, I do.
All right, thank you. All right, moving right along to new business. This conversation and item was to be discussed in closed session this evening. I was informed that Mr. Kimber would like this to be an open session, so I'm looking for confirmation from either him or his legal counsel.
Yes, put that in writing several times.
I appreciate that, thank you.
Yep.
All right, moving on, we then will have this meeting in open session. I would like to then have Todd Terry start our conversation on the village's side.
So if we could though, we did raise this objection to your attorney, and I think we should raise it now, at least from what I understood of the notice, it says that you'll be discussing the possibility of going into open session, and then, which you guys knew about, and then acting upon anything discussed in closed session, but I don't see anything noticed for discussion or action that's not either to be the discussion, to have a closed session meeting, or to act upon what was done in a closed session meeting. So I understand we don't have any proper notice for this hearing. That's why it's really important that you guys know that you had this information well in advance of 24 hours ago, that we were clear on the moment that we got the notice from you, which was something like 4 business days ago, that we wanted this to be an open session. So you guys had the opportunity to notice this correctly so that we could be clear. But as we've informed your attorney, that's something that doesn't seem to have been addressed. Thank you.
I appreciate that. I believe, and so does this board, that this is noticed properly. So, Todd, if you could start on, please.
I think Jim will weigh in on the notice issue.
Yes, good evening, everybody. Jim Carroll, Bureau of Veteran Labor and Employment Council. I agree, Mr. President, that the meeting was noticed properly. It clearly states that Mr. Kimber would have an opportunity to request that the meeting be in open session and that any final action taken be in open session. And if that is his request, I don't disagree with his counsel that he conveyed that previously, but obviously we want to be sure that if there was a change of heart or a change of mind between that time and now, that the opportunity to remain in closed session was still there. So since he's confirmed his desire to proceed in closed session, I think that's appropriate, but the notice does indicate as that much.
I would agree, and so does this board.
We confirmed, really, to be clear, that we had notified you the moment that we had your notice 4 business days ago that this was to be an open session. We then reconfirmed it in writing that we didn't want this to be, or that we wanted it to be a public session. And now you asked us again, but it seems clearly for the purpose of setting a record here that doesn't seem to be as accurate as it could be, which again, as I've stated, we gave you plenty of notice. You chose to act the way you did.
I appreciate your input. I feel it is accurate. Our legal counsel feels it's accurate, and so does this board. So if you could start, Todd, I'd appreciate that.
Yeah, just some background context, just for tonight's purposes. Mr. Kimber is here as an employee of the EMS department for the Village of Waterford. Nothing herein deals with his employment status with the fire department for Waterford. Totally different procedures there outside of this board. It's certainly the village's position, and it's supported by Wisconsin statutes and case law, that Mr. Kimber is an at-will employee of the EMS departments under WSStat 17.13. And again, just to reiterate, what's before you tonight is the EMS department employment status. It's not the fire department. Totally separate issue, totally separate procedures outside of this board. One thing that's a little bit different tonight is the village president, and I think this board has concurred in providing Mr. Kimber and or his counsel basically redress in front of this board, the ability to speak in front of the board, and the village president will certainly address that as the time comes. So procedurally, that's a little bit, this is not a hearing, it's not an evidentiary hearing, it's a board meeting for one single purpose, obviously, but it's being conducted a little bit differently in that regard to extend some privileges that maybe don't attach.
Mr. President?
Sure, Trustee Burke.
Just for clarity, given the protection of all employees under the village, we've always done closed session in matters like this. Why are we doing this now? What's the precedent to let Mr. Mr. Kimber open up to the public, because this is not about Kimber, this is about all employees. Why are we doing this in a public forum when we typically discuss HR issues in private?
It's the employee's decision.
Fair enough. All right, thank you for clarifying.
Just for some background and context, So just for some background and context, what got us here, maybe a timeline. As this board, there's some different iterations of this board, but back on May 7th of 2024, by ordinance, the board at that time adopted a split of the fire service from the EMS department, thereby creating the EMS department and the at-will employment status of the employees within the EMS department. So that kind of sets the context. Here, the performance issues that are before this board relative to Mr. Kimber that resulted in him being placed on paid administrative leave effective August 2nd, 2024. Really three key points based on the village administrator's actions at that time. And that was, and I'm certainly not an expert with this, but there was an issue with the ground ambulance data collection that was required through CMS for Medicare and Medicaid reporting. Lieutenant Kimber took on that role. The reporting was not timely completed. It resulted in a reduction in recovery of fees that the village was entitled to based upon that less than timely reporting. That was confirmed by Mr. Kimber in an email, I believe it was August 1, in exchange with Mr. Jackson, the village administrator at that time. The second issue that was raised at that time was a discovery that there were several expired medications on one of the paramedic rigs, or both of them. I do not know exact specifics of that, but there were several expired medications that led to those being yanked off the rig, and essentially a mass order that had to be processed quickly. And then the last one, when Mr. Kimber was moved out of his position as interim EMS director, his subsequent successor discovered that the DEA logs, which as I understand are required for narcotics that are kept on ambulances or paramedic rigs, that those logs were sufficiently or severely out of date and had to be updated. Those are really the three things that led to the action for paid administrative leave. Mr. Kimber, since that time, as you are aware, has filed a complaint with the Equal Rights Division, state of Wisconsin. That complaint is pending. There's a hearing this summer on that. This thing has drug out a long time, no doubt about it. Some of that has been a result of change in personnel. Mr. Kimber changed attorneys, which is his absolute right. And there have been substantial and repeated negotiations to try and resolve this matter. I will not go into specifics of those, but there have been efforts to do so. So that's kind of what brings us to this point tonight, albeit a long time after it started. What's before this board with an at-will employee for the EMS department, pursuant to your personnel handbook, you have several options tonight. You can return Mr. Kimber to his employment status, take him off of paid administrative leave, and return him effective immediately, whatever you want to do with that. You certainly have the right to continue him on administrative leave, paid or unpaid. You have the right to impose discipline upon him. And then lastly, it's certainly our legal position, you have a right to terminate him as an at-will employee. Whatever happens tonight, there's additional recourse or redress available to Mr. Kimber pursuant to the village's personnel handbook and a grievance procedure under the personnel handbook, which really mirrors state statute, and certainly redress outside of that as well. That's all I have.
Okay. Anybody up here have anything they need to follow up on with Mr. Terry? All right. As Todd did say earlier, I am more than willing to listen to Mr. Kimber if he has something he would like to say, or one of his legal counsel. We are not going to spend a half an hour, or 2 hours on this, so if that could be done in a expeditious manner. I think those of you in this room that know me, I'm willing to hear what has to be said, so I would like to hear if anything needs to be said.
Counselor, 1 second.
Great, thank you all. So my name is Ben Hitchcock Cross. I represent Lieutenant Jared Kimber. We've asked several times to my colleague here, Mr. Carroll, to be clear on what exactly are the charges that are pending against my client. He's refused to do so. We now heard, I was trying to take notes here, but it seems like, and really unable to follow, but even by the admission of the in-house counsel here, he's not really aware of the specifics of much of what the allegations are against Mr. Kimber. It's also my understanding that these allegations against Mr. Kimber were made by the former village administrator. We're very clear that the village administrator has gone well above what the state law authorized, both in this village here, and what his plans were for the splitting of the fire department and the EMS department, to say the least. And to be clear, what he was doing was a power grab to put some of the public services who would normally be under the fire chief and a police and fire commission under his control. And that's clearly what he was doing here. I spent much of this afternoon reviewing what happened in May of 2024, and it's very clear that the purpose of that and many of the actions that were taken at that time were done to reduce the powers of the elected officials, the appointed officials, and to increase the power of the administrator. And that, I think, is, to be very clear, in the context in what we need to talk about. Now, I know my colleague, the in-house counsel here, has pronounced and has stated several times that it's the position of this board that my client is at will. Okay? Now, that may have some important meaning, but before we get to that, we have to understand that my client is a firefighter, was employed as a firefighter, was appointed as a firefighter, and there's nothing that I've seen enacted by this board that has ever stripped him of his position as a firefighter. Now, they claim here that he is on the EMS side, so therefore he's at will, and then you all can do whatever you want. And I do take some little, have to push back on something my colleague, the in-house counsel here said, is that the state statutes mirror, that handbook mirrors the state statutes. In fact, and I read a lot of handbooks, it's one of the most unclear and gives the employees the least possible protections that they could have. Now, that may be what you have wanted, but it seems to me that that is more in keeping of the trajectory of the village administrator, who again I understand that you've removed, has increasing his power and decreasing your power. And if you look at the EMS statutes, ordinance that passed on that day, it's very clear that who is in charge of the EMS? It says the EMS director reports to the village administrator. So now we get back into the state statutes. And now my client here has a lot of roles as a firefighter. And one of those is to leap into burning buildings, another is to save lives, but another is to follow the statutes of the state of Wisconsin because he has a license that he needs to protect. So do law enforcement officers, like my colleague over here. They have a specific external duty and license, just like teachers do, that they need to maintain so that they can continue working because they're state standards. And it doesn't just matter what the village administrator says, it matters what the people of the state of Wisconsin says. That's the law. That's how we agree to be run. So when it came to be that there was a conflict with what the people of the state of Wisconsin had said that the Lieutenant Kimber had to do, and between this village administrator, he used his powers against my client. So we can't, it's hard for us to respond to whatever these charges are because we don't, I mean, it's clear that not even you know them, or you'd have the guts to have told us ahead of time when we asked for it several times. It could have been stated when we asked for it several times. It wouldn't have to been no. Okay? Which gets to another very important point, that even by my colleague's own admission here, there's no point in having this hearing. There's absolutely no point in doing it. Because apparently Mr. Kimber has no right to the hearing. You say he's at will. You say he can do whatever he wants. So what's the point of him responding? It's very clear. Again, we're going to get right to what's the point of him responding. And I think all the people here have the right to know what's going on and the purpose of all this. We have been engaged in negotiations. Why? Because my client filed a complaint with the state of Wisconsin against the village. So we've been in negotiations to resolve those claims and the fact that you put my client on leave but are not paying him his full salary, and you're making his family destitute. You're harming him. You're retaliating against him. And even if it was the original retaliation of the city administrator, that's all on you. And we can hear very clearly from my colleague here, the in-house counsel, what did he say? He said this is drug out a long time. So instead of responding to our negotiations, our offers and counter-offers, this is the response. Well, and you know that, right? The village president here is nodding his head. It's all very clear that this is the response here. They say they can do whatever they want. So, going back to the clear point, when we look at the record, there has been nothing that's ever been shown to me that I can find on your website, which I do believe is actually very good. Very clear, very easy to find what you're looking for. And you go look at the ordinance. It doesn't say anywhere. It references a specific statute which falls under dismissal. And this basically, the statute allows you to lay off employees that have just cause protection for certain reasons. And although that's invoked, there's nothing in the statute. There's no paperwork that my client has ever seen. There's no hiring process. There's nothing to say other than a budget maneuver, as far as I can see, that his position is anything other than subject to just cause, and that the provisions of that statute, because it doesn't say you can do whatever you want, it says that there's a specific order that things have to go in. There's no evidence that I've seen that seniority was followed, just for starters. But you've arbitrarily classified him conveniently to the power grab of the village administrator, so that you all can then say he's at will. And I suspect, again, that you all know that that's false, and that you all secretly know that this is part of the negotiation process here, and that you all have discussed this amongst each other before today, which would also be another open meetings law violation here. Why? Because this is part of the negotiations. So, we have clear retaliation, and it's clear that this is part of the process and in response to the ERD complaint, straight out of the words of my colleague's mouth. It's all drug out too long. Okay? So you all have decided, you've given yourselves the power to do whatever you want. You've given yourselves the power to judge here. It doesn't, even if there was an allegation against my client, the person to bring it is the EMS director. You don't even begin to have any authority over this issue, which again makes it clear until it's brought to you in the form of a grievance. That's just assuming that it's true that he's a so-called at-will employee. The more evidence that you all know that this is part of the process. So, you've given yourself the authority. You've given yourselves the power. You're going to do what you're going to do. And this is ultimately a political decision. So then who do we look to? We look to all the people who are sitting here today. And we think, is this the right decision? Is this the moral decision? Is this the politically wise decision? Well, that's up to you. But legally, I've given you several reasons why it's not the correct decision, despite what my learned colleagues here, who are looking down furiously at the pieces of paper, have advised you altogether. So, if this is your strategy, do what you will. There might be more to come. Thank you.
Thank you, Attorney Cross. I appreciate it. Anything else the board needs clarification on, follow up on, any type of information before we discuss what our legal counsel offers options?
Yes. Could you read back, Attorney Terry, what you said about an email exchange?
That was on the CMS or Medicare Medicaid reporting. There was an exchange between Mr. Kimber and Mr. Jackson on August 1 of 2024. I'm paraphrasing, but essentially Mr. Kimber acknowledged that the reporting was not completed at that point in time, and it was substantially late at that time.
Thank you.
All right, anything else from anybody up here? Trustee Britt?
I'm just trying to understand the retaliation accusations when we broke up fire and EMS due to budget restraints due to the deficit in our EMS facilities. We broke that up in finance to address a problem. I don't think that was retaliatory. So I don't find those grounds valid, and I kind of take offense that this is political when we're trying to do the best interest within the village.
Okay.
I'd be happy to explain that.
This is not a trial. So I listened to you guys. I'm listening to you as an elected official. I appreciate your input.
Great. He asked a question.
We're not going to go back and forth. He was making a statement. Were you asking a question or making a statement?
Making a statement.
Thank you.
I understand. Can we still respond?
I let you speak, Attorney Cross.
I heard. I was there.
Okay.
I remember
I'm
that.
glad that you were there. We
Right.
all were there. We have people who record it, so we can watch it again if we
Sounds
want.
like a no.
It is a no.
Okay.
Does anybody else up here have anything else to say? Or any clarification from our legal counsel? All right, hearing none, I need somebody to make a motion on whatever we would like to do here.
I will make a motion that Mr. Kimber is an at-will employee with Waterford EMS, and in conclusion of his administrative paid leave, I recommend termination for all of the items that Attorney Terry mentioned: untimely filing of Medicare and Medicaid patient bills with CMS, costing us on collections, failure to properly oversight the meds that were expired left on rigs, and additional expense to resupply those, and delay in getting those orders done. The DAA logs and reports not being properly filed, and him acknowledging that they were out of date. And that is my motion.
All right, I have a motion. Is there a second?
So moved.
All right, we have a motion and a second. Is there any other conversation on this topic amongst this board? All right, hearing none. Rachel, can I please have a roll call vote?
Nash.
Aye.
Goldammer.
Aye.
Holnell.
Aye.
Jaskey.
Aye.
McReynolds.
Aye.
Dunham.
Aye.
Ewert.
Aye.
All right, a unanimous roll call vote. Mr. Kimber, your services with the EMS department are terminated effectively at 6:25 p.m. on April 6th, 2026. I'm looking for a motion to adjourn.
So moved.
Second.
I have a motion and a second. All in favor?
Aye.
Aye. Any opposed? Hearing none, the meeting is adjourned at 6:25.